I've seen thousands of probate applications submitted. Many delays aren't caused by complicated legal issues, they're caused by small document mistakes that are completely avoidable. So, in this video, I'm going to walk you through what you actually need based on what I've seen go wrong in real life and how to avoid those mistakes. Now, most estates don't require the full inheritance tax forms, so I'm going to start with what applies almost to everybody, the probate application itself. And then later in the video, I'll cover the additional documents you need if you do have to complete an IHT 400, because that's where things can become more involved. If you're not completely sure what applies in your situation, there is a full step-by-step guide on the website. You'll find the address on the screen. At a basic level, most probate applications come down to three things: the death certificate, the original will, if there is one, and the probate application itself. And that, of course, sounds straightforward. But this is exactly where I see people run into problems. And the frustrating part is most people don't realise until after they've submitted. Starting with the will. The Probate Registry expects the original document. And one of the most common issues I see is people taking the will apart to scan or copy it. They will remove staples, separate pages, and then try to put it back together. It is innocently done, of course, but from the court's point of view, it creates uncertainty. They can't be sure that nothing has been removed or altered, and that often leads to delays and further checks before probate is granted. The death certificate itself is usually more straightforward, but where it catches people out is when it's not in English. If that's the case, you'll need an official certified translation. Not something informal, it has to meet the required standard. And this is something people often only realise after submitting the application, which then stops everything while it's corrected. Another area where people get tripped up is sending too much to the court. In most cases, you do not need to send bank statements or routine valuations or lots of supporting paperwork. People will naturally often think, I'll include everything just in case, but it doesn't help. It can actually slow things down because the application becomes harder to process. So unless something is specifically required, in most cases you should not include it. Where you do need to be careful is if anything has changed with the executors. For example, if someone named as an executor is not acting, you'll need to include the correct form, such as a renunciation form. If that's missing, the application won't be processed properly, and you'll likely get a query back, which slows everything down. There are also a few smaller things that regularly cause issues. If there are any codicils, an amendment to the will that is, they must be sent with the original will. If there are multiple wills, for example a UK will and a foreign will, they both need to be submitted, but not older versions of a UK will, only the latest will is relevant and to be submitted. Even simple things like names not matching across documents can trigger queries. These are the kinds of small details that don't seem important at the time, but they're exactly what trigger queries from the Probate Registry. If you're applying by post, there are also a couple of very practical things to watch. You'll need to include the application fee, and this catches people out more than you might expect, because a lot of people don't have checkbooks anymore. So you may need to arrange a check through your bank or post office. And when you send the application, you are sending original documents, including the will. This, of course, applies if you're making an online application as well. So it's really important to use special delivery. Losing those documents would create a much bigger problem. Now, if you do need to complete an IHT 400 as the inheritance tax forms, this is where additional documents come into play. And this is where I tend to see more complexity and more mistakes. You may need property valuations if the estate is taxable. You may need valuations for higher value items such as antiques or collections. You'll also need to include the relevant supporting schedules depending on the estate. And in some cases, where authority is being relied on, documents like lasting power of attorney needs to be included in full, including all pages, not just the pages where information has been entered. I've seen cases where people have gone to the effort of getting a RICS property valuation and then forgotten to submit it. HMRC then referred it to the district valuer and ended up having to argue for their own valuation to be accepted. All of that could have been avoided just by including it at the start. The key point here is that the forms will guide you on what's required. The problem tends to be either missing something that is needed or sending far more than is necessary. Both can cause delays. So the main takeaway is this. It's not about sending everything you have, it's about sending exactly what's required and nothing that isn't. Because most probate delays that I see are entirely avoidable. If you want to understand the full probate and estate administration process, what to do, in what order, and what to watch out for, I've put together a detailed guide called Probate's Done Properly. And if you want to sense check your situation before you submit anything, I offer a 30-minute clarity call where we go through it together. And you will find both linked below.